Hello and welcome to Legally Speaking with me, Tarun Nangia. In this part 2, we're going to discuss a strong message that Justice C.T. Ravi Kumar, Justice Sanjay Kumar have given to all the high courts across the country. And that message is on liberty. It is on bails, where they have gone out and this communication has been sent to all high courts that bail applications should be listed at the earliest because personal liberty is at stake. This is a strong message, and the two judges in who have done it, Justice C.T. Ravi Kumar and Justice Sanjay Kumar, definitely deserve praise because we all know how these situations can be when people are behind bars, and in our country where trials take forever to finish, liberty is of paramount importance. I have a panel who have dealt with these issues or do deal with these issues on a day-to-day basis. Uh, Let me introduce you my eminent panel today. I have with me Justice Talwant Singh, who is now a senior advocate at the Supreme Court. He's now on the other side. He argues for many high-profile clients, but one of the most respected judges of Delhi High Court who was on this roster. He dealt with many of the contentious matters that were the highlight of the press in those days. The beauty of it is that today he's going to share his opinions both as somebody who sat on the bench and as a senior advocate who now argues for a lot of, he defends a lot of the accused. Good to see you, sir, and looking forward to some interesting insights from you.
Yeah, thank you.
I have with me Advocate Sanjeev Sharma. Sanjeev Sharma is partner dispute resolution practice or the litigation practice of one of India's leading law firms, namely Saraf and Partners. He deals with such matters on a frequent basis. We have with us Archit Singh. Advocate Archit Singh is a partner at Saraf and correct myself. Advocate Archit Singh is a partner at Circle of Counsels. It's a law firm specializing in financial crime matters, ED matters, PMLA matters, SFIO matters, and a lot of commercial fraud matters also. And he looks at such issues on a day-to-day basis. He advises clients on these issues. So he will give us his insight on these issues. Good to see you.
Thanks,
and looking forward to some your interesting insights from you as well. At the outset, may I request Justice Talwant Singh, now senior advocate at the Supreme Court of India, to share his insights on this communication by Justice C.T. Ravi Kumar and Justice Sanjay Singh.
Yeah, no, thank you, Tarun. Basically, this is an issue which is time and again flagged by the Honorable Supreme Court. Bail and anticipatory bail, these are two limbs which should get the priority listing in high courts. But what is happening in high courts across the country is that they are being paid on one reason or the other. The anticipatory bail is filed by a person when he is anticipating that he may be arrested in a crime, and regular bail is filed by a client who is already in jail. So, in the first case, there is a threat to his personal liberty. In the second, the personal liberty is already curtailed, and he, on some ground or the other, wishes that his case may be considered for release. As it has been time and again said, that personal liberty is of paramount importance. Illegal detention in a case, even for a day, is something which is unpardonable. I was a practicing lawyer initially, then I joined district judiciary in the year 2000. And most of the time I remained on the criminal roster in district courts, although I was a civil lawyer initially. So, and especially I was on bail duty in most of the jurisdictions because lawyer never wanted me to go away from the bail roster. I don't know why. So in district courts, if you move a bail application today by 3 o'clock, the bail application is immediately listed on the next day. And if a notice is to be issued, notice won't go beyond a week. It may be for 2 days, it may be for 3 days. When I was elevated to the High Court, I have seen that a notice in bail applications will be issued at, normally after a month or so. So why this practice is there? I try to cut short even that time. But because the same investigating officer who has answered or who has filed the status report before district courts, he is going to file almost the same status report in High Court also, maybe with few more developments which have taken place in the interregnum. Otherwise, the report is going to be the same. So why he needs a month or so for filing the same report, it is beyond me. Secondly, in case of anticipatory bills, the case and which was before Honorable Justice C.T. Ravi Kumar, is he has shown attention to this person at least deserves some consideration. Because if you see the in the case of the first matter, the other SLP, that person had also moved an anticipatory bail application, but he was arrested in the meantime. So this is another thing. If you are going to adjourn the anticipatory bail application without fixing a date, or with fixing months bond that was taken up and no interim protection, bail application itself become infructuous.
Okay. Okay, point well taken. But in bits and pieces, I was unable to hear you. But I think largely it's been coherent. I'll take this point to Sanjeev Sharma, partner dispute resolution practice at Saraf and partners for his opening comment.
Yeah, thank you, Tarun, for inviting me. I think it's a very, very important and substantial because the language used in the judgment is very categorical. The court says that the high courts, all high courts are required to ensure the listing of the anticipatory and the bail matters. It does not say that please make an endeavor. So ensure is a very clear and categorical direction to list it, to put lot of emphasis on the liberty. And I think this is in sync with the vision of the present Chief Justice also, who immediately after taking over as a Chief Justice clearly put a lot of emphasis on listing of the bail matters, and he has given very clear directions that bail matters are something which are required to be given a lot of emphasis, and that's why directed that each bench must have bail matters for the disposable. This is one. And I think there are series of judgments in last 1.5 years which put a lot of emphasis on disposal and early disposal of bail and anticipatory matter because it relates to the liberty of an individual. And if you recollect, I think in May 2023 also Justice Gawai and Justice Karol has given a judgment, and two very important and substantial matters they clarified. They say that there should not be too much of gap between once a bail order or anticipatory bail matter order is reserved and passing of the judgment. And secondly, they say that do not dwell too much on the merit, on the evidence of the matter. So the endeavor and the effort of the Supreme Court is to clearly put a lot of emphasis on passing of a judgment on bail and anticipatory matters at the earliest. See, what is important is that whenever the anticipatory bail, especially the anticipatory bail, is filed, it is because of two reasons. One, a person is anticipating a threat to its liberty. They feel that they can be arrested anytime. So it could be before filing of FIR, it could be before, after filing of FIR. But if you delay passing a decision, there could be two issues. One, the person may be arrested and the anticipatory bail may become infructuous. And this is what actually had happened in this particular Kavish Gupta's matter. Or the threat abates. So even then also it becomes infructuous. So I think this is a very, very important judgment which has been passed, and a direction has been very clear and categorical to all the high courts to ensure the early listing of all the anticipatory and bail matters. I really give a thumbs up to the judges that they have taken this effort to pass such kind of a direction in that categorical time.
Okay. Thanks for sharing your view with us. One thing that I am though reminded that Supreme Court in the past 2-3 years has on a few occasions reiterated this, that bail should be something that should be taken seriously by the district judiciary and the High Court also. Secondly, we also saw the Chief Justice of India, Justice Dhananjay Chandrachud at the Supreme Court level, saying that 10 bail matters should be heard by benches every day before the normal course of the day starts. I'll take this to Archit Singh, partner from Circle of Councils. Archit, one thing I want to know from you, the court has again felt the need to reiterate, that is Justice C.T. Ravi Kumar and Justice Sanjay Kumar, they have felt a need to reiterate. Why do you think this happened?
So, Tarun, if I may, and I echo exactly what Mr. Sanjeev Sharma has rightly pointed out, that there is a overarching theme. It is not this one order, but an overarching theme that the Supreme Court is sending a message that it is the bail that needs to be given priority. There has to be some semblance of importance that personal liberty deserves in this country, and which is why an expeditious disposal of the same is something that has been the priority of the present regime as it comes out to be. Now, this order of the Honorable Supreme Court today, recently, where they have stated that the urgent listing should be considered, that listing needs to be a process which cannot be discarded, is very important. You see, listing is one of the primary processes where the thing starts. But as Sanjeev rightly pointed out, that is not where it ends. There is more to it that goes on. And see, in my personal experience, what I felt is there have been times where orders have sometimes even been reserved, for example. Now, everything has happened on time, but maybe a month, 2 months, 3 months have passed by, and nothing has really transpired. There is no order. Now, this puts the litigant in a very awkward position at times. The awkward position being, I am left remediless. What do? Do I go and mention? See, litigants are also scared. It's a discretionary relief at the end of the day. You don't want to badger a court as well. And second, what I felt in my experience, overarchingly, what has caused some more problems are, as Justice Talwant Singh rightly pointed out, what is the reason that people require so much time? You know, the same officer in district court is filing in a week. The same officer requires 4 weeks. Now, it actually goes much ahead. In my experience, what I've seen is at times there are endeavors, even by the High Court, to list a case on a particular date. So they'll take into consideration, okay, 4 weeks to file a reply, 2 weeks thereafter to file a rejoinder. And the matters thereafter taken into consideration, the 6th week probably placed on the 7th week. So it's expeditious in the one point of view. But what practically happens is it is the state agency tends to, more often than not, file their reply on right before the date. Now, what happens is my right to file a rejoinder will either get frustrated or I must take a date to file a rejoinder. So, overarchingly, the expeditious relief, there is a tendency that it extends. Somewhere over here, I think some indulgence needs to be shown on the administrative side, that how can this practice be curbed? How can expeditious disposal be given a real effect? Listing is definitely a positive step, but it is first step in a series of steps which we think is required.
Now we have an interesting juncture. We have two law firm representatives here, namely Sanjeev Sharma from Saraf and Partners and Archit Singh from Circle of Councils, and senior advocate Talwant Singh, who in a sense defends his clients before the Supreme Court. So on the one hand is a pressure that they have to handle because they have to deliver to the clients. And what goes on here when they are facing the court and bail is denied? Because I think it's a very high pressure situation there because there are expectations from both ends. And that's why we will discuss on the attitude towards bail. Now, sir, you argue not only in Supreme Court, but at high courts across the country. And do you see difference in attitude towards the issue of bail in different high courts in your experience?
Yeah, I think time and again, it is being said by the lawyers who are practicing in those courts, not by me, that Delhi High Court is the best high court as far as the listing is concerned. You file the bail application, and it's not, I'm not saying so out of my own experience. I'm just sharing the experience which has been shared with me by the counsels who are appearing all over the country. Okay, as far as the court in the neighboring state of Uttar Pradesh is concerned, whether it's Allahabad bench or the Lucknow bench. Once you file the bail application, nobody knows when it is going to be listed. In Delhi High Court, at least there is a certainty that if you have cleared objections, everything you have done today, it will be taken up on the board tomorrow itself. So the first thing is that there has to be a certainty, and that certainty is lacking in many high courts. And of course, Supreme Court, it takes some time to remove the objection, but at least you are sure of the listing part. As has been already said, that listing is just the beginning. It is the first step. But at least let us cross that hurdle first at the earliest. Then this response, Archit was, I think, a little more modest, saying that the responses are filed day in advance. Archit, the responses are filed on the same day. I have seen in my court, the public prosecutor just hands over the copy across the board to us, okay, across the bench to us. And he said, sorry, sir, I have filed it. So we ask them, when have you filed it? They say that it was filed early in the morning. So before coming to court, they file. So there is no occasion to share a copy with the other side. So after a few days, I started telling the public prosecutors, you please carry additional copies for the counsel for the applicant also. So that at least today he should have a copy. Other days, sir, I have got only one copy. I am handing it over to you. So, and I'll go through the police file. It must be a copy, must be there. But I think this is what is happening. I don't know what is the reason. Same IO, same police station, same SHO. They respond to district courts very promptly and not to the High Court. And again, I think we can't say that the High Court has got more pressure than the district courts. In Delhi, we have got 11 districts, and my own estimate about Delhi High Court is that we have got, I think, 8 or 9 criminal benches as on date, and most of the time, throughout the day, only these miscellaneous matters or the kachi-peshi matters, we say they are being taken up. Hardly any time is available for regular matters. So, but in district court, I don't know whether Tarun, you know it or not, we are supposed to handle the bail matters and thereafter to conduct our regular trials, and there is no exemption given from units. We are supposed to give a particular number of units in district courts. There is no exemption given, and these bail matters hardly account for, I think, 10 or 15 units. So somebody is supposed to give 120 units, and this is just a part. So the judge sitting in district courts will dispose of the bails for that particular district, and thereafter he'll be doing his regular court work. Whereas in High Court, sometimes I think the lawyers who are appearing in High Court, I have seen it from the other side, they will vouch for it. Most of the court, the whole day, only these quashing and bail applications are being taken up. The reason maybe, I think I'm not going to blame only the judges. The reason is that the lawyers address lengthy arguments and they try to show judgment, this, that. I don't know why. Because in bail, you have to simply just put up your case on the factual side. All the judges, they know the law. There is no need to reiterate the law in every case before the judge. Okay. So this is what my take.
You put it so beautifully. Justice K.V. Vishwanathan recently said that a man had lost his 3 goats and he believed they were stolen. So he went to a lawyer, and the lawyer was appearing before the judge, and the lawyer was quoting Julius Caesar, the Roman Empire, and from every other historical tenet. Finally, the man who lost his, or his 3 goats was stolen, he told his lawyer, sir, everything you have said, just tell the judge about my 3 goats. They have been stolen. So we can empathize with the predicament of the judge that, he is getting to know all history from the lawyer except for the 3 goats that were stolen. So this is what Justice K.V.
I'll share one line joke with you. Some lawyers will come and tell us, Lordship, bail is the rule and jail is an exception. I said, oh, I'm really thankful to you that you reminded me of that. I was not aware of this. So I think sometimes you raise arguments only for the sake of argument, which simply wastes the court's time. I think one should directly come to the point. And I think the court will be able to take up more matters, and especially those regular matters which are pending for years together. Some time may be devoted to those matters also. But of course, lawyers are lawyers, and you have to manage your board. So I knew the technique of managing the board, and I used to complete my kachi peshi maybe by 11:30 or 12 every day. So those are secrets of trade, you can say.
Quite well taken. I'll go to Sanjeev Sharma, partner, Saraf and Partners. Sanjeev, two things here. First is, do you see that as a whole across the country, district courts are a bit hesitant to give bail, so every work is pushed to the High Court? And when the High Courts become reluctant to give bail, then matters land up in Supreme Court, and then Justice C.T. Ravi Kumar and Justice Sanjay Kumar have to send this message to High Courts that list cases and give bails. Why everything has to land up to my table or our table in the Supreme Court? It's a constitutional court. Your view on this whole architecture?
Absolutely. I think this is a fact. Nobody can deny this fact. In fact, this was also acknowledged by Justice Chandrachud when he took it over, and he made an observation in one of the matters that district court are reluctant to grant bail, especially in the heinous crime matters. So in heinous crime matter, they feel that there would be repercussions once they give the bail. Obviously, there would be a challenge before the High Court and the Supreme Court, and there may be a lot of strictures against that. So they are obviously very reluctant, very slow to grant the bail, and ultimately matter comes to High Court and the Supreme Court. So I think Justice Talwant Singh raises a very important point. This particular judgment of Kavish Gupta touches only on the listing issue, but Justice Gawai's judgment touches on the issue of disposal of the bail matters and the anticipatory. So I think listing is an issue which is more particular and more relatable to the High Courts, not to the district court. Justice Talwant Singh has made it very clear that in district courts, yes, obviously you file it and the matter will get placed before the judge. Delhi High Court is no doubt blessed. We have such a fantastic processes, and the procedures that you mentioned in the morning, the matter would get listed in the afternoon. But lot of high courts, there is so much of delay, especially the Allahabad. Justice Talwant Singh talked about the Allahabad High Court also. But I believe so. I think they also have the reasons because they have a lot of matters each day. They have, I think most of the judges have 300 matters each day. So the listing would become very difficult. So I think this particular judgment of Kavish Gupta deals only with the listing, and that's why directions only to the High Court. So, and the issue which you just raised is, it is actually an issue. I think we need to sensitize the district judges also, that they need to be very proactive. They need to be very clear. If a case requires a bail to be granted, it has to be granted. Obviously, it is a cliche that bail is a norm, not the jail. This was something which was passed in the judgment in 1975 by Justice Krishna Iyer, but recently became very popular. So most of the lawyers normally, when arguing the bail, they say this. But I think district judges are required to be sensitized more for granting the bail requirement of a person to be free in case there is other conditions which can be fulfilled. There are a lot of conditions. Obviously, we are not required to dwell on those conditions right now. But if a case requires, it is required to be dealt with, should be dealt with forthwith, immediately, and if bail is required to be granted, it must be granted to save the liberty.
Okay, point well taken. I'll go to Archit Singh, Partner, Circle of Councils. Archit, whether it is reserving of orders by the judges or otherwise, there is a great deal of what you can say pressure in bail cases on the lawyers also, because it's a question of liberty. It's not a routine case. When liberty is concerned, lawyers undergo a lot of pressure. What do you want to delve on this aspect? Because when the court says early listing of cases, that is the Supreme Court, that is Justice C.T. Ravi Kumar and Sanjay Kumar, all of these things go into their mind. It's a predicament of the lawyers, the accused in that case, and also what happens if he is unfairly incarcerated for a long time. Could you share your experiences on this?
Tarun, I would say it's not that much of a burden on lawyers. And I'll say that with some responsibility. See, the main burden is on the person who's in jail. You have to understand there's someone who's under a plight. They're incarcerated. There's obviously a criminal proceeding going against them. There's obviously a proceeding in the public going against them as well. See, incarceration in India is not just incarceration, you sitting in a jail or you coming out. It also impacts you socially, publicly. If you're a businessman, your business. If you're a person working at your job, then you lose your job more or less. So what happens? Now, naturally, all of this burden is the limited burden that a lawyer has to only share, but it is the litigant who has to suffer through. So I think as lawyers, our focus has to be on early listing. Like, I'll share some examples. So sometimes what we ended up doing is, the law, as Sir rightly said, there are times where the lawyer would come in the morning and say, "Here is the application." We would say, "Okay, fine, list it in the afternoon. We are ready." Because at the end of the day, it is the facts which we are aware of as lawyers. And if, as long as we are aware of the facts, the law, as far as bail is concerned, has not changed so drastically in the past 50 years. The rudimentary and fundamental aspects that it arises out of are the same. So I think that, with that in consideration, we should always move forward.
Okay, point well taken. I'll go to Justice Talwant Singh. The fact that, sir, the Supreme Court required to give such a message, what do you think has, in a sense, gone in the minds of Justice C.T. Ravi Kumar and Justice Sanjay Kumar for them to be giving such a message to the High Courts? Is there a sense that things are not going the way they should, and that's why this message for the High Courts across the country?
Yeah, I think as my panelist has earlier pointed out, granting or not granting a bail is the first prerogative of the district courts. When I was in district courts, of course, in those good old days, I would rather say, we have not seen matters regarding under Section 307, 308, and all other matters of the similar type going to High Court for bail. Generally, the matters which are being taken up by High Court for bail, I'm talking about Delhi, were regarding dacoity, rape, and murder, and serious financial crimes. All other matters, district courts were disposing of the bail applications, and there were certain parameters which we were following, and the cases were progressing well. When I took over charge of the criminal side in Delhi High Court, I saw that every second matter, every third matter is being pushed to the High Court. Of course, I think a time has come. The High Courts, especially Delhi High Court, they keep on reminding the district judiciary that you have to take a call on this. Saying in every matter, this is a very heinous crime, so no bail is made out, or without any proof saying that if the person is bailed out, he will influence the witness. You need certain ground to say so. Okay. Basically, non-grant of bail is against the basic principle of bail is a rule. You can't prejudge a person who has been arrested in a case and start his conviction without there being a trial. So it's a conviction before trial. This is what is happening nowadays. And the district judges, unfortunately, they feel safe if they reject the bail. So I also go to judicial academies. I keep on telling them, okay, if somebody has to blame you that if you have granted the bail, it means you have shown undue favor to the accused, okay, or the under trial. Okay, I think with the same brush, we can paint it and say that you have shown undue favor to the complainant. Okay, in these times, complainants are as active as the accused or the under trials are. So, saying that or thinking that if I reject a bail, nobody can raise a finger on me. I think even on rejection of a bail, a finger can be raised because somebody may say that you have shown undue favor to the complainant. They have to keep this in mind. So we tell them you have the only thing which a district judge should do is to maintain consistency. Okay. It should not be that in one case he has granted bail on the same facts, and in the very next case, on the same facts, he will not grant a bail. He may not grant bail. That should not be there. You have to apply the rule. Yeah, you have to apply the rule. Yeah, and you have to go as a consensus. The lawyer should believe you that if such and such type of case will come before you, most probably this is going to be your decision. Nobody is going to raise a finger on you. Okay.
Okay.
But yeah, so the high courts dockets are clocked. Hundreds of bail applications are filed every day. So we can't blame only the judges. Basically, the district courts have shifted their burden to the High Court. And in some cases, High Court is pushing the docket to the Supreme Court. Supreme Court is not supposed to sit in bail jurisdiction. They have got many other serious constitutional matters to discuss. Okay, there are hardly, I think, we have got 35 judges in Supreme Court. It's a whole big country of 140 crore people. So I think again the message has to be conveyed to the district courts. Please do your duty. Please dispose of the bail. Look at the jails. In Delhi, we have got, I think, they double the number of under trials in Tihar jail. Okay, there is no place for them to sleep during night. So what type of jail facilities we have provided them? And I'm giving you an example. During Corona, as per the Supreme Court, Honorable Supreme Court's directions, every High Court was supposed to form a high-powered committee, and on the recommendation of the high-powered committee, there were certain categories of people who were, released on bail. Okay, most of them have returned back to the jails without there being any default. They remained on bail as per the recommendation of the High Power Committee for 2 years. Nobody had hampered the trial. They were participating in trial, and once those and exceptions are there. Exception people may come on interim bail and they may jump the bail. Those exceptions are there, but I'll say 99%, 99.5% people, they have complied with the conditions. They have surrendered back wherever they have been asked to do so. If they can remain on bail and their cases can proceed further, why should we detain them in jail? I can't understand.
Okay. Very well made point. Very well made point. We'll take last two interventions. Sanjeev Sharma from Saraf and Partners. Sanjeev, we see many times businessmen spending half the tenure if they were convicted. Say if you're convicted for 7 years, you already spent something like 40 months in jail already. So, and then they coming for bail. Do you think that without trial, keeping people inside for a long time should be then on the radar of the courts?
Yeah, so I think it's a cliche again. I think it's often repeated that justice delayed is justice denied. So that's why the emphasis not only on disposal of the bail and anticipatory bail application, but also the listing, because it's travesty of justice that even that listing takes time. Then obviously the hearing on the bail and the disposal of the bail, either ways, whether granting or denying, rejecting it, is something which will definitely take time. So I think what the court's endeavor is that at least wherever it is possible to cut short the time, whether it is listing or the disposal, they must do it. And just to answer what you asked me, no doubt about it, if a person who's alleged or charged for an offense where the maximum punishment is 7 years has already undergone 3.5 years, and after the trial is like they feel that the charge has not been proved, then ultimately it's no doubt it's a very big injustice to that person. So that's why if the person has spent less of time in the court, bail is granted if it is possible, then I think this is something which is very important for a person's liberty. That's why the courts have stated that delay in granting of the bail or the anticipatory bail violates the mandate of the liberty. So I think that's a very important message which has been sent by the Supreme Court. And a lot of judgments, especially this one. Yeah.
Point well taken. I want to ask Advocate Archit Singh from Circle of Counsels on what Justice Talwant Singh said. He said about lawyers not getting straight to the point. Since you practice extensively in the courts, do you think that said to be brief when you argue your matter and get straight to the point is very important?
See, I agree with Sir wholeheartedly. And see, I've been blessed that way, that my mentors have also given me that same teaching, that the right way to argue is to get to the point. See, there's no point in going to a court talking nonsense for some time, skirting around the issue. And, at times the judges do often just pointedly say, okay, we understand, but what about this? So it is very important that you address. There are times judges themselves are giving you cues that, listen, we've understood rest of the matter, but can you come to this little point that requires some consideration? So factually assist us. We know the law. Especially if you're sitting in front of a roster which is dealing with bail, they've heard that same judgment 10 times in that day. Imagine someone again and again coming reading the same judgment, I'm sure by now the judge can also say, Manu Patra, this is the paragraph number of SCC, that is the paragraph number. I know, don't worry. So naturally, the right way is to get to the point. And as I said previously, it is, especially when it comes to criminal law, if you can master the facts, the law follows. And that is why I think having some experience in trial courts and the district courts, I think there is nothing more important for a lawyer than to learn and master the facts. Because once you've mastered the facts, it's very easy to get to the point. And it's very easy over time when you gain experience to understand how much facts do you need to state to get to a point. Because I'll tell you, Tarun, I was one day in Supreme Court. There's a time when I was clerking and on the other side of the bench with behind an honorable judge. And there was a relief that a lawyer was about to get. It was a bail relief. But he overextended. He stated more facts that were needed, and the bench was on the way of typing out a judgment. And then the judge just rose his head and said, wait, what did you say? Can you clarify further on the 3 points you've said now? And suddenly the entire case became from a case of bail to no, we don't think a bail is made out. So one should know not to overspeak and stick to the grounds that you require. I'm not saying fool the court. One should always state everything that is there, but know when to stop.
That's very beautifully put, Archit Singh. Brevity is important. Getting to the point is important. I really appreciate all the three panelists joining me today. An important message given by two honorable judges, Justice C.T. Ravi Kumar, Justice Sanjay Kumar, regarding bails and listing of bails. Listing is important. The matter will be heard. It will go one or the other way. But at least a man should not spend months before his case is listed. We all have to thank the Supreme Court for what it is doing, sending messages to the High Court. And of course, in our wish list in January, the show that we'll do, we'll discuss this more because that will be our wish list for 2024. And this would be one of our final shows on bail for this year. I would like to thank Justice Talwant Singh, now senior advocate appearing before the Supreme Court and other forums, Sanjeev Sharma, partner, dispute resolution, Saraf and Partners, Advocate Archit Singh, partner, Circle of Counsels, for joining me on this really important issue. And viewers, thank you for tuning in. Thank you so very much.
Thank you so much, sir. Thank you, everyone.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.